Hello, I'm Yozua Makes, and I'm the founding and managing partner of Makes and Partners Law Firm.
Hi, and I'm Iwan Setiawan. I'm a senior partner and head of the capital market practice group at Makes and Partners.
To start off, let us briefly tell you about our law firm. Makes and Partners is an award-winning, top-tier, independent, innovative, and creative Indonesian law firm. Based in Jakarta, and a leader in the Indonesian integrated corporate finance and corporate commercial legal services market. Recently, we were internationally recognized as the best capital markets law firm in Southeast Asia by a very prominent international publication. I established Makes and Partners in 1993, and our firm is one of the most senior law firms in Indonesia, with 30 years of recognized and proven professional excellence. From its inception, all of us at the firm have adopted the guiding philosophy that solving a legal problem means more than just knowing the law. Indeed, our end-to-end legal advice through the lens of a consolidated commercial, business, and optical approach, resulting to our high completion rate for our deals, spells out the real difference, and is what truly sets us apart and above other law firms. Simply put, our client trusts our unparalleled commercial and practical legal approach in handling our transactions, resulting to our successful reputation in the Pan-Asia region and renowned high completion rate in the market.
Adding on to what Yozua had mentioned, we are especially proud of our firm's award-winning capital market practice group and its achievements. We have been called as the powerhouse of capital markets and the best independent law firm in the capital market space in Indonesia. True to our guiding philosophy, the firm always comes up with ways on how we can reach our client and provide our insight on the practical application of the laws in their commercial transaction.
This is why today we want to talk about some general concepts and salient features of the newly enacted P2SK Law from the lens of its general commercial impact to capital markets transaction in Indonesia. Law number 4 of 2023 on financial sector development and strengthening, or the P2SK Law, was newly enacted on 13 January 2023. It is another pioneering and breakthrough omnibus law in Indonesia, like the breakthrough job creation law, and was enacted to amend existing laws and introduce new concepts and practices, this time to the Indonesian financial sectors. While the P2SK Law encompasses many aspects and other areas of the Indonesian financial sector, such as fintech, crypto, and banking, in this brief interview, we will only focus on the P2SK Law's salient amendments on relevant Indonesian capital market laws. In general, the law affects various segments of the Indonesian financial sector, including banking and insurance sectors. It also provides significant development and changes to one of the driving forces of the Indonesian economy, the capital markets sector. The P2SK Law also strengthens the authority of the Indonesian Financial Service Authority, or the OJK, as the prominent supervisor and regulator of the financial sectors in Indonesia. In a nutshell, there are 16 Indonesian laws involving Indonesia financial sector that have been partially amended by the P2SK Law. For capital market transactions, there are a number of notable laws that have been partially amended by the P2SK Law, such as the Law on Capital Markets under Law number 8 of 1995, or the Capital Markets Law, which has not been amended for almost 28 years, and the Law on Financial Service Authority under Law number 21 of 2011, which was enacted almost 12 years ago. Finally, aside from providing major updates to the relevant laws in the financial sectors, the P2SK Law also aims to keep up with the times and addresses new market practices and cover a wide variety of new products and financial instruments, including those with tax-based innovations, which are used in the Indonesian capital markets.
The OJK has confirmed that the P2SK Law aims to achieve the following objective as it relates to the Indonesian capital market. Number 1, the enhancement of the financial markets. Number 2, strengthening of law enforcement. Number 3, the enforcement of the investor protection. Number 4, development of the trading infrastructures. Number 5, strengthening of corporate governance. Number 6, financial market stability. And number 7, enhancement of consumer and investor protection. As the P2SK Law is very new, we expect that various implementing regulations will be enacted in the future in order for these objectives to be met. First is the IDX demutualization. Before the P2SK Law, only securities companies that have obtained business licenses as securities broker from the OJK may become a shareholder of the stock exchange. The P2SK Law now allows other parties to become shareholders of the stock exchange. And the second breakthrough is the flexibility of for mutual funds. Before the P2SK Law, our capital market law prohibits borrowing and lending of money by mutual funds and purchasing share or participating in units of other mutual funds. Under the P2SK Law, mutual funds are now able to carry out these activities subject to compliance with certain requirements that will be imposed by the OJK. Another breakthrough is the introduction of carbon trading and exchange. The P2SK Law also introduces a relatively new activity in the Indonesian capital market, which is carbon trading. This establishes a framework for inducing a green economy. The P2SK Law introduces the establishment of a carbon exchange to facilitate domestic and foreign carbon trading in Indonesia, and the recording of ownership of carbon units.
The P2SK Law also introduces the inclusion of several refined definitions in the capital market law. For example, the term securities was defined in the 1995 Capital Markets Law as traditional commercial papers with an enumeration of certain types of securities available in 1995. Almost 3 decades have passed, and the global capital markets have dynamically evolved ever since. The P2SK Law intends to capture those dynamics by redefining the definition of securities to encompass wider components and expanding the coverage of securities, even covering digital ones that are subject to the capital market law and its implementing regulations. It is also a clear indicator of the efforts taken by the government to cope with the fast changes in capital markets and technology and the increasing variety of securities and its derivatives. Similarly, the P2SK Law also provides more details on the subjects that are considered as affiliate under the definition of affiliation in the capital markets law. Overall, the amendment makes the definition clearer, but at the same time wider. The amendments on the term affiliation and securities are important to note, as they automatically expand and redefine the scope of eligible securities and affiliated party transactions that are regulated and supervised by the OJK and subject to the capital markets law requirements. For example, if somewhat a transaction is considered as an affiliated transaction, with a party under the revised definition of affiliates under the P2SK Law, the relevant issuer would need to conduct disclosure of information, obtain a fairness opinion, and in certain instances, approval from the independent general meeting of shareholders. The P2SK Law has formalized this protection by amending the capital markets law. For instance, a legal basis for the mechanics on the change of status of a public company who wants to become a private company is now expressly stated in the capital markets law through the P2SK Law. Based on Article 84A of the amended capital markets law, it is stated that a publicly listed company may voluntarily change its status to a private company for as long as the company fulfills the requirements that are stipulated in the relevant OJK regulations. While the capital markets law still refers to the go private mechanic set out in OJK regulation number 3 of 2021. This is still an improvement, as prior to the enactment of the P2SK Law, the mechanics for go private was not recognized in the capital market law, but only in OJK regulation number 3 of 2021. The P2SK Law also formalizes the disgorgement principle as previously regulated in OJK regulation number 65 of 2020 on compensation funds for investor losses. The P2SK Law also formalized mechanic for customer funds protection mechanism that may be established for certain securities crowdfunding initiative/instrument. As previously regulated under OJK regulation number 37 of 2018 regarding IT-based crowdfunding services via public offerings. The expectation and hope is that this formalization measures by the P2SK Law would eventually increase the confidence of public investors in the capital markets law in Indonesian capital markets.
The recognized go-private mechanism by the capital market law under the OJK regulation number 3 of 2021 should be carried out by public companies or issuers that have been delisted by the stock exchange or have been instructed by the OJK to go private or have voluntarily changed their respective status to again become a private company. Even though the go-private process primarily protects public companies, issuers, and their respective controlling shareholders, it will also benefit public investors who are stuck in the public company that have non-performing financial and don't have the ability to cash out their shares in the stock market. The go-private process, which usually commences with either a buyback of shares or voluntary tender offer, will provide these public shareholders with the chance to have their shares purchased at an attractive or at least reasonable price as per the required floor price. In relation to the go-private process, our top-ranked capital markets practice group has also introduced the Markets and Partners Creative Squeeze-Out Strategy, which provides a breakthrough solution to address the issue of squeezing out unreachable shareholders of a public company, which is a crucial factor for the success of the go-private process. The solution has not been addressed by OJK Regulation number 3 of 2021 or even by the P2SK Law. For more information about this, feel free to visit our firm website for our special newsletter on this topic. Another essential breakthrough under the P2SK Law is the strengthening of OJK authorities over the activities of financial institutions. In imposing sanctions on criminal acts or violations in the capital markets, the P2SK Law adopts the una via principle or one pathway principle. This principle gives special authority to the OJK to determine whether a particular conduct violating the capital market law should be subject to criminal or administrative sanctions. Effectively, this will help minimize the time-consuming and costly nature of imposing only criminal sanctions to violation of the capital market law. Similarly, the disgorgement principle, now formalized in the capital market law by the P2SK Law, now enables the OJK to impose quicker and more practical administrative sanctions in the form of monetary compensation, and thus provide direct relief to any affected investor. Aside from the above authorities, the P2SK Law also now grants additional authority to the OJK in obtaining assistance from law enforcers to accommodate travel bans against parties suspected of violating any capital market laws and regulations. Prior to the enactment of the P2SK Law, their liabilities and responsibilities for violation of the capital market law were only borne by and limited to the action of activities conducted by solely the directors, employees, and other parties working for the relevant companies, excluding the ultimate and or controlling shareholders from the list of accountable parties. Now, however, the liability extends not only to individuals but also to corporations or legal entities for criminal actions. Secondly, the P2SK law now amends the capital markets law to regulate that all relevant parties of a public company may now be held accountable for the action and or activities conducted by the various entities. Consequently, this expansion of liability places greater emphasis on the awareness and diligence required from more parties in committing any action relating to or regulated by the capital market law and its implementing regulation.
Notwithstanding the new changes, improvement, and empowerment of the capital markets law at this time that we have shared with you, there is no concrete evidence or certainty that the reform, development, and strengthening of the financial sector as initiated or desired by the P2SK law would actually be realized. There is no certainty that a judicial or constitutional challenge similar to what happened to the job creation law would not be raised, contesting the validity of the P2SK law. However, we believe that despite these uncertainties, the worthy goal of the P2SK law provides exciting and progressive new opportunities for the Indonesian capital markets as a long-standing driving force for the nation's economy. It should also be anticipated and noted that the OJK in the near future will issue various implementing regulations as instructed by the P2SK law. And it is our hope that the OJK will acknowledge and address any unfinished and unregulated aspect of the current regulation, which are crucial for the proper implementation of the relevant capital market rules and regulation.
As the chairman of the Association for Capital Market Legal Consultants of Indonesia, I can say that the road to an orderly, reasonable, and efficient capital market is perhaps still a long and challenging journey. But several improvements in governance and investor protection for the interests of various participants of the Indonesian capital market are clearly visible and attainable under the P2SK law, and hopefully in upcoming executive initiative and implementation under several relevant government ministries and, of course, the OJK. The P2SK law effectively demonstrates that the Indonesian capital markets strongly support constant yet progressive development on its regulation and enforcement measures, which are amongst the crucial components for manifesting the Indonesian capital markets as a resilient, stable, and sustainable driving force of the Indonesian economy.
Thank you for your time, and we hope you found this general presentation useful. Please feel free to reach out to us at Marcus & Partners Law Firm if you have any questions or wish to discuss with us about your transaction. Thank you.